I didn't see you driving, but I can still arrest you unless you know how to protect yourself. I'm lawyer Andrew Flushy, and I'm going to bust some common myths about traffic stops with Officer Andy's help. How are you this evening? What can I do for you, sir? And how much have you had to drink tonight? Wait, you didn't pull me over. This is called a consensual encounter. An officer can walk up to you and talk to you for any reason, and if you consent to talking with them by responding, they don't need any reason for that interaction. If they actually pull you over as a traffic stop, then they need reasonable articulable suspicion to do that. But a consensual encounter requires zero justification from law enforcement. Let's see how you should handle this situation. How are you this evening? I'm fine, I hope you are too. I'm leaving. Now Officer Andy has a choice to make. If he tells you to stop, he must be able to back that up with reasonable suspicion. This is what we call a Terry stop, based on the Supreme Court case that justified this kind of police encounter. Or Officer Andy can decide to just let you walk away. By telling him that you're leaving, or by simply just continuing to walk, you don't even need to respond, you've put the burden on him to decide whether or not he's got some reasonable suspicion to believe you've committed a crime or that criminal activity is afoot. If he has no suspicion that he can actually articulate that would hold up in a court of law, odds are you're just going to keep on walking. But if he decides to tell you to stop, now he's got to justify that in court, and that could give you fodder to fight later on. Whoa there, partner. Stay right there and talk to me for a minute. Where are you coming from this evening? I was downtown. When did you drive to this location? About 10 minutes ago. All right, let's do some quick tests to see if you're good to drive. But you never saw me drive anywhere, but you just admitted to it. This is why you never talk to the police. They will push and prod and ask questions in certain ways to get the information that they need out of you to try to prove what they think you may have done, even if, frankly, you've committed no crime. If the police officer thinks you've committed a crime, they're going to ask pointed, directed questions designed to get the kind of responses they need to try to confirm their suspicions. If you simply don't talk to the police and refuse to answer their questions, you won't convict yourself. Now, the police may still be able to gather evidence that you've done something wrong, but at least you're not going to give it to them on a silver platter. Here's a better way to handle Officer Andy's questions. Whoa there, partner. Stay right there and talk to me for a minute. Where are you coming from this evening? Am I free to leave? Not right now. I got some questions to ask you. Where are you coming from? I'll remain silent. Now Officer Andy would have to prove that you drove that vehicle in some other way. Perhaps he saw you drive, or perhaps he has some other witness, or maybe he can get some kind of surveillance video to prove that you were the driver of the vehicle. But the most important thing here is you didn't incriminate yourself. Your own statements aren't going to be used to hurt you in court in this case because you didn't give any. Every statement you make to law enforcement can and will be used against you in a court of law, unless there's some exception that we can use to try to keep it out of evidence. But assume that every word you say can and will hurt you in court. Let's look at two other common misconceptions. Where are you coming from this evening, sir? Richmond. When did you drive here from Richmond? About 10 minutes ago. All right, I'd like to have you do a few quick tests to make sure you're okay to drive. I'm on private property, so you can't arrest me. You didn't even pull me over. There's two big misconceptions wrapped up in this little scene. The police can approach you on your own property, even your own driveway. Now, there are some limits here, but in general, your driveway or a private parking lot of a business, for example, would be open for the police to walk on. If it's your own residence and you have a no trespassing sign out at the road, that would be a different story, and there may be a good defense there if the police didn't have reason to come onto your property. That no trespassing sign is telling people that they are not welcome on your property, and that includes the police, unless they have adequate justification to do so. A related issue here is that you can be found guilty of DUI, at least in Virginia, for operating a vehicle solely on private property, even inside your own garage. It's pretty crazy if you think about it. But the law says that you cannot operate a vehicle under the influence of alcohol anywhere in the Commonwealth, even if it's your own private property and the vehicle literally is on blocks in your garage. That could still get you a DUI. That's the way the law works in Virginia. The second big misconception here is that the police do not have to pull you over in your vehicle in order to charge you with some kind of traffic offense or DUI. They simply have to be able to prove that you were the driver, that you did commit that offense in the vehicle. Now, they may be able to prove that through different ways, and frankly, a lot of times the way they can prove it if they don't see you actually driving is based on your own statements. So always remember, don't talk to the police. For more tips on how to answer officer questions, be sure to check out the next video. I'll see you there.